they nuts? What you need to know about an ERISA disability approval letter that tells you that they're only going to pay you based on a psychiatric condition. Congratulations! You've gotten a letter from your disability carrier or plan saying that they're going to pay you your disability benefits. But as you read the letter, much to your surprise, they tell you that the payment of benefits is conditioned on their idea that you have a psychiatric condition and that your benefits are just going to be limited to 2 years. When in fact you might be disabled from a physical condition like Lyme disease, fibromyalgia, or any other condition. That's good news and it's bad news. Well, the good news is that you're going to be paid. However, the disability carrier or plan is always looking for a reason to limit the payment of benefits. And one of the ways they do that is to take the position that based on the terms of the policy or plan, your disabling medical condition is psychiatric in nature rather than physical in nature. That tactic is used depending on the terms of the policy, as there are some policies or plans that will limit the payment of benefits to just 2 years if any type of mental or psychiatric condition contributes, regardless of how small it is, to your overall disability. I call this the Monty Python rule. Now, you might have a back condition, and you might be depressed. That's reasonable. You might have fibromyalgia, and because of your pain, you're depressed. You might have Lyme disease, and you have panic attacks over the thought of just taking a walk in the park. The disability carrier or plan just might take the position that because of that minor contribution, you are disabled as a result of a psychiatric condition and not the underlying physical condition. So that's the bad news. The bad news is that they've announced that while they're going to pay you, they're only going to pay you for a short period of time, which can be 12 months to generally 2 years, at which time they're going to exercise their right to deny your claim on the basis of the mental nervous policy limitation. It's key that you understand that right now. You need to understand the terms of your policy so you can develop a strategy in conjunction with your lawyer to address the application of the mental nervous policy limitation period. And it might be that you have multiple medical conditions that are disabling and they need to be addressed. And it might be that you need to be talking with your psychologist or psychiatrist and confirm with them that they don't think your problems are contributing to your disability. So you want to make sure that the doctor is addressing the de minimis psychological issues and that you are not disabled as a result of that. On the other side, you want your medical doctors to confirm that you are disabled as a result of your physical condition and that there is no psychiatric contribution. So you can see it takes teamwork here to work with your physician and your other treating providers, and that strategy needs to be implemented now. You're on notice that they're going to deny your claim regardless of the nature of your physical problems. So use that time wisely. Consult with an experienced ERISA disability attorney who will review the policy, review your medical records, and work with you in developing a winning strategy that will hopefully limit the carrier plan's ability to successfully raise a mental nervous policy limitation defense. Give me a call at 727-894-3188 for a complimentary consultation.